You're allowed to smoke if there's no clause in that original lease.
For a rent-stabilized building, the current lease says no smoking or pets allowed, but the original lease from 55 years ago never said that. Do I have the right to have a pet or to smoke?
If the original lease did not restrict pets or smoking, you can have a pet and you can smoke in your apartment. And if the landlord were to try to evict you for having the pet, you'd win the case because of that original lease. If the original lease contained a no pet clause and was then renewed, that clause would project. If you then get a pet, New York has a law that says that if the landlord finds out about the pet and doesn't take any steps for 3 months after obtaining that knowledge, then they can't enforce the clause. The issue of how they obtain that knowledge is very broadly construed. So if the super saw the dog, or if the doorman saw the dog when the tenant walks it at night, that knowledge is imputed to the landlord. And from that first encounter, after the passage of 3 months, that dog is protected. It would not protect a subsequent dog. In other words, the 3 months would start running every time you get a new pet. Emotional support animals are an exception. If you have a bona fide need for an emotional support animal, you have a diagnosis from a social worker or a psychologist or a psychiatrist, you have a right to have a pet despite what the clause says. And I have yet to see a landlord fight a claim of an emotional support animal. It's almost an impossible case for them to win because the courts generally don't want to get involved in doing a psychiatric examination of the tenant to see if they really need one. Now, the smoking issue is a different issue. This comes up a lot. Again, the same rules apply with the lease. If there's nothing in the lease, then yes, you can smoke. Buildings are now required to have smoking policies. Some buildings are considered no smoking anywhere, in apartments, anywhere in the hallways. However, those rules can't be imposed on rent-stabilized tenants. What happens in these cases is that very often a tenant is smoking and the neighbors are complaining. The neighbors say the smoke is traveling from that apartment to mine. My kids have asthma. It's aggravating their asthma. I'm not unsympathetic. But what the law requires in that situation is that the landlord takes steps to stop the smoke from traveling from one apartment to another, either by, installing some kind of negative airflow or something like that. And you're allowed to smoke if there's no clause in that original lease.